Hello. We're going to consider the concept of rights this time. We're going to consider broadly enough so that it encompasses both legal and moral rights. So the broader concept of rights. This is a good time to consider the concept in the course because we've done utilitarianism, we did Kant. Kant is a formalist or a deontological ethical theory. Rights correspond most closely to a deontological ethical theory. It's a deontological concept. Consider the what's the relationship between the concepts of right and good? We can distinguish consequentialism from formalism in terms of that. So for utilitarianism as a variety of consequentialism, right depends on good. Good is prior to right, logically. So rightness is determined by goodness. What's the right action? The one that produces the most good. On theological concepts, on the other hand, it's the other way around, or rather, right and good do not have that very close relationship that they do for consequentialism. So what establishes right, of course, is the task of any deontological normative theory. But the concept of rights with an S is something else again. What do rights? So rights are an ethical institution or a legal institution. They perform a function in society. And broadly, that function is to mark out the scope of action for us within which we can be confident that we can act with, well, not with impunity, but confident that we're justified in what they're doing. It also determines what it is that we can expect of other people, what we can assume of other people. So they're a very important concept for it in a social institution, ethical institution. We'll consider the relationship again between rights and duties. In particular, are they strictly correlative? That is, if someone has a right, does that imply that at least one other person has a duty? We'll discuss that. Of course, well, we're using the concept so that it encompasses both legal rights and moral rights. Interestingly, it's legal theory that informs ethical theory to a large extent when it comes to rights. And that's not surprising, is it? That the law is adversarial. The law does weigh rights against each other, people's rights. That's what judges do. So that it's possible for rights to conflict, and then we need adjudication between them. Let's begin this way, that by distinguishing types of rights. Here we go right away to a legal theorist, Wesley Hofeld, who early in the 20th century distinguished 4 categories of rights: claim rights, liberty rights, power rights, and immunity rights. Claim rights are the category that we're primarily interested in, where we will argue that rights moral rights are valid claims. So to have a claim right implies that one is in a position to make a claim, that one can make a claim, that is to make a demand. Right there, that's very interesting, isn't it? Because we said that rights, moral rights, claim rights would imply the capacity to make a claim. We often use rights to protect individuals or populations, like children, senile people who can't argue for themselves. In the abortion debate, fetuses we can accord rights. Animals, we can accord rights, perhaps. So what's interesting about that is that the most vulnerable populations are often those which cannot exercise a demand. Now, legally, of course, you can have proxies. You can have somebody who will take that role for them. But morally, that's more problematic. If somebody isn't able to make a claim, then that suggests that they don't have a right. Because to have a right is to be in that position, to be able to do that, to be able to exercise your claim, to make your claim. Does that mean that we can do whatever we want then with populations that aren't able to make a claim? Of course not. It just means perhaps that we might need another concept to support our intuitions that people do, that deserve certain sorts of behavior from us. What is it's claim rights. Next is liberty rights. This is more clearly, a little more clearly a legal concept, but liberty rights basically are this negative idea that you have a right to do whatever is not prohibited. This could be by law or by morality. Say somebody lives in a quiet subdivision of white clapboard colonial houses, and he wants to paint his in neon colors. He has a liberty right to do that if there's nothing that prohibits, if there's no ordinance says that prohibits him from doing that. So liberty rights allow us to do things that are not prohibited by some authority. The right to freedom freedom of speech would be a liberty right, in that the Constitution creates an injunction against Congress to limit that kind of activity that we want to exercise. Power rights are more clearly a legal category. A power right is a right to do something based on some prior action that we took. And a simple example would be posting your property with no trespassing or no hunting signs. Once you have taken that action, then you can take people to court who cross your boundaries without your permission. Immunity rights are the converse. It's the immunity from the power of somebody else. The constitutional provision against double jeopardy. You can't be tried twice for the same crime. Diplomatic immunity. Diplomats are immune from the laws in which where they do their work. They may be deported, but they can't be indicted, brought under the law of those communities. Now we come to the central importance of rights as an institution, as a moral institution. What do rights do for us? Their primary importance is to justify, give an especially strong justification for acting contrary to some collective good. And this shows us why rights are a deontological concept. A collective good is a good whose importance is simply how much there is of it, as opposed to who has it. So, utility would be a collective good. Remember the utility monster. Utilitarianism has nothing to say about the distribution of utility. All that matters is that there be the maximum of it. What else is collective good? The gross national product, the general welfare, other concepts of collective goods. So what rights allow us to do is to allow a single individual to stand up against what's better for the majority of people. This is a very powerful and provocative idea, isn't it? And this is what makes rights so provocative, that somebody can stand up and stand on their right, even when it's worse for the majority of people. So if somebody wants to put an old beater car up on blocks in his front yard and it ticks off his neighbors who are worried about their property values or something, says, by God, he can do that. That's his right. He owns that. So that's pretty powerful. It must rest on pretty important conditions too. So if somebody has a right, then these two conditions have to be satisfied. First, it must be possible to individuate the right holder. You must be able to identify that person, either by name or by characteristics, as in, say, a class action suit. What matters is not your name, but that you are a member of an aggrieved class, that you have the characteristics of membership in that class. Notice the difference, again, with utilitarianism. So what matters is not, remember, a negative responsibility. If you're in a position to stop some bad thing from happening and you don't, then you're blameworthy for that. because what matters is the maximization of utility, not one's personal values or who does it. What matters is that it happened, period. So right holder must be individuated. Second, the right or the claim that's at the center of the right must be based on an especially strong moral consideration. Because if you're going up against what's better for them, then you must have a pretty good reason for that. What could that be? Obviously, it's not going to be utility, maximization of utility. What else is there? Well, what does Kant give us? Perhaps respect for persons, human dignity. That you can't use people as tools for other people's goals. That's it. That's the most important function that rights have, to enable individuals to justify their actions, even when it's worse for everyone else. But now we have complication. The concept of defeasibility or defeatability. The theoretical consensus is that all rights are defeasible, are defeatable. That's the same thing as to say, so that if all rights are defeasible, no right is absolute. All rights are prima facie rights. A prima facie right is a right on its face, or as it first appears. All this means is that, again, that there are no absolute rights. Any right potentially can be outweighed by something else. Like what? Well, like another right. Rights conflict. We said in the law, that's why we require adjudication in the courts to determine whose right has priority under the circumstances. Utility, how about that? Yeah, we just said that the importance of rights is that it gives you the justification for acting contrary to the maximization of utility. But let's face it, we want a concept of rights that's practical too. And if you keep piling on the utility on one pan of the scale, at some point it gets pretty plausible that it should win out against other people's rights. Well, how about that? Have we just eviscerated our concept of rights? On the one hand, we just said the most important function of rights is to provide a justification for acting contrary to the maximization of utility or some other collective good. Now we say no right is absolute. Any right can be outweighed potentially by the maximization of utility. Here we can make a distinction that'll be helpful. The violation of rights versus their infringement. I'm sure you've heard that. To infringe a right, what's the difference between violating a right and infringing a right? To violate a right is always wrong. To violate a right is to ignore the right altogether. To infringe a right is to weigh the right against other considerations. So infringement is sometimes justifiable. It depends on the circumstances. For example, consider the state in building a highway. Eminent farmer's property to put a highway through. He has no recourse to that. The state can do that. Now, is that the end of the story? Too bad for you, farmer. It's better for everyone else. Too bad for you. No. What happens? Well, farmer gets compensated, doesn't he? Fair market value, supposedly. No one is ever happy with that, but the interesting point is why? Why should you compensate somebody? If you're utilitarian and you determine that it's better to the maximization of utility to see somebody's property, why isn't that the end of the discussion? Because he has a right to his property. We see the force of the right. He deserves compensation. Now, he's not going to get the content of the right, but the right gives us guidance. He has a right. We want to say that he deserves consideration. More than that, deserves compensation. That's what the concept of right or rights does for us. All right, so let's look at it analytically. Now let's analyze the concept of rights into its pieces. First, conditions of possession. This will tell us under what circumstances somebody would have such a right. Some rights we have simply by being born, rights of citizenship. Other rights come into being under particular circumstances. That's when you get a title to an automobile, it's when you pay for it. Rights can be forfeited, that are nullified or transferred. You buy a car, you can sell it and transfer it. To sell it is to transfer the right to it to somebody else. Scope is second. Scope is the content of the right. What is it a right to? Third, weight. Weight gives us guidance in adjudication between rights and other claims, or between two different rights. So to say to speak of the weight of a right is to say, or rather to say that a right is from prima facie, is to say something about the right's weight, but nothing about its scope or its conditions of possession. Fourth, conditions of engagement. When is the right in effect? Some rights are in effect all the time. We don't have to do anything. The right to life would be such a right. Other rights we have to invoke in order for them to have force. So if you win the lottery, you have to show up with a ticket. Next, whom the right is against. This, if we're speaking of claim rights, this would be the case. So to say with a claim right, if somebody has a right, someone else has a correlative duty. So to have a duty is to be able to say, I have this right against somebody or against these people. Next, a normative element. A normative element would be the core value concept. So when we said that there are claim rights, liberty rights, power rights, and immunity rights, those are normative elements of rights. And last, a system of norms. Basically, this means either legal or moral. These are separate systems, different categories of rights altogether. And a last important distinction is that between positive and negative rights and duties. And in this case, positive goes with positive, negative with negative. So if somebody has a positive right, that implies somebody else has a positive duty. A negative right implies possession somebody else of a negative duty. A positive right is a right to something from someone. So, and it corresponds to positive duty. And it's a positive right because the duty requires a performance of something. To discharge your positive duty, you must get up and do something. So if I borrow my neighbor's basin wrench, he has a positive duty to get it, he has a positive right to get it back from me. I have a positive duty to return it to him. A negative right is a right to be left alone in some respect. And a negative duty correspondingly is the duty to leave people alone in that respect. The right to life is a negative right. It's a right not to be killed. It's not a right to be kept alive. All of the rights in the Bill of Rights and the Constitution are negative rights. Freedom of speech, right to bear arms, freedom of assembly, freedom of religion, freedom of the press, and so on, are again disable Congress from interfering with those activities. There's something like a consensus that the most important rights are negative rights. And that suggests, again, something about moral theory, and that usually we're more interested, or the more plausible moral theories are narrow sense moral theories. So if we're dealing with a rights-based morality, what we're looking for are constraints on things that we already want to do. We don't go to morality to give us goals, to tell us what the good life is. We want it to tell us what we should not do. So again, right to life, for example, Bill of Rights seem to capture something more important more basic intuitions than positive rights might. Now, so that's the analysis of the concept of rights. We want to turn next to this idea that rights are valid claims, which seems to be something like a consensus, that moral rights are claim rights. And here we're going to turn to a very important paper written by the philosopher of law, Joel Feinberg, and he delivered at a conference at Ripon College back in 1971, I think it was. It's Feinberg who gives us the most important argument for rights being valid claims, and that's what he does in this paper. He does it in a very interesting way. He gives us a thought experiment. And as he wants us to imagine a place called Nowheresville where no one has any rights. No one even has the concept of rights. So it's like Milwaukee, except nobody has any rights or even understanding of the concept. What he wants to do now is to build in as many features of a recognizable moral life that we can. So if we build in as much as we can without incorporating rights, that will tell us the importance of rights for a moral life. What are we missing at the point at which we can stuff all kinds of moral concepts into this place and not have rights, and then we'll see what rights do for us. So, what kind of moral life is possible without rights? Well, what is possible morally? First, he says, in such a place you can have virtues. Virtues in particular of say sympathy, compassion, pity. In other words, just because there are no rights doesn't mean that people have to be nasty toward each other. It doesn't imply that the people are nasty toward each other. They can genuinely care for each other without that implying that there be any rights. Next, they can have duties. What? Doesn't that imply rights? Well, yes, if we're talking about claim rights, that implies a correlative duty, but there's another concept of duty, which is a duty in the weak sense as simply what is required by some authority or other. This is Kant's concept of duty. This duty, so when we say only actions done from a sense of duty have moral worth, the sense of duty is simply that we're commanded by reason to do something in particular, or not to do something. So what would that authority be? Well, it could be the law, it could be scripture, it could be one's conscience even, just some recognized authority. That in itself doesn't imply rights. Next, he says the concept of personal desert. This is fitting behavior. That under the circumstances, it's just appropriate that somebody do something in particular. He gives the example of the lord of a medieval feudal manor. It says on his estate or on his, he's a baron, he's the absolute law in his domain. He has a servant, and the servant does a particularly good job. The lord believes the servant deserves a reward. Now, notice, what is the nature of a reward? A reward is appropriate under particular circumstances, but a reward is not something to which you have a right. That's the idea. So social institutions such as rewards, such as tips, such as bonuses, these would be covered under personal desert. The behaviors that in society that we understand to be appropriate, but that's about it. So, for example, we sometimes hear stories about somebody leaves a wallet or an envelope full of $20,000 in the back seat of a taxi. The cab driver finds it and remembers who that fare was, returns it, able to track the writer down. And the person who lost the money gives the cab driver $20 for a reward. Now, that's outrageous, we might say, but it's not a moral. It may be a fault of character, but it's not. He's not violated any right that the cab driver has. Tipping. So a lot of this is fairly close to etiquette, isn't it? Consider tipping. The tipping is what originally was a reward, wasn't it, for good service. Now, if you don't leave a tip, you're a jerk, regardless of how poor the service is. That's the idea. So this sort of social institution varies with time. This it's a little dubiously moral in that sense, closer to etiquette. Finally, Feinberg gets really creative here. So far, we have virtues, weak sense duties, the kind of behavior that's appropriate under the circumstances without creating a right on the other side. What else? Are we there yet? I mean, does that give us a recognizable moral life? And he says, no. What about institutions like property, contracts, deals, appointments to office, loans, marriages? Don't all of those imply rights? So if you're going to have even a moderately complex form of social organization, that suggests that we will need rights. So he incorporates rights at this point, but in a very particular way. Here he borrows from the English 17th century political philosopher Thomas Hobbes. Hobbes, in his great work Leviathan, imagines the sovereign, the king, who is a absolute power in his kingdom. He can do whatever he wants, basically. And among his subjects, there are rights. They have property, they have loans, they have deals, marriages, and so on. So they have rights against each other. But here's the wrinkle. All the corresponding duties are owed. So you have rights between people at the bottom, but all the corresponding duties go up to the king. King has the monopoly on duties. You owe it to the king to do these things. All right, that's a very nice theory in Leviathan. Is there anything like that in fact? Well, Feinberg says maybe during moral development, maybe children at some period of development have this sort of attitude. So you have two little boys, Billy and Bobby, they're brothers, very young kids. Billy hits Bobby. Dad sees this. He demands that Billy apologize to Bobby. Billy thinks Bobby's dirt, doesn't owe him anything. But he owes it to his dad to do this. Something like that. Or maybe in theology, the idea that it takes three to marry. You have behaviors owed to each other, the rights against each other among the couple, between the couple, but the duties are owed to God. Or let's say insurance would be like this. So you have the insured, the beneficiary, but then the insurer holds all of this together. Okay, so that would give us the behaviors that we need that rights cover. Property, deals, contracts, all those things. What's missing? So we have the behaviors that we need. What is missing? In the article, he think of the sense of duty that we have, the weak sense. That you owe it. So they have traffic lights in Nowheresville, like anywhere else. But there, if you go through the light, you collide with somebody, then what do? They stop, wait for the cop, chat amicably. Something missing there? Or think of somebody who buys a new Lexus. He's just driving it off the dealer's lot out into traffic, and somebody collides with him. Damages his car severely. What would they do in Nowheresville? Again, just get out of their cars and wait for a cop. What's missing there? Outrage, indignation. I've been injured. There's no sense of that in Nowheresville. There's no basis for indignation. What do you owe it to the law to stop, to obey the traffic regulations? You don't owe anything to each other in Nowheresville. So that Feinberg says that very important part of our moral experience of being offended, that I have a right not to have this done to me, is no part of anyone's experience in Nowheresville. And that's what rights give us, something he believes is very important. So rights then what's missing? Claiming that I make a demand that people not do this to me, that I have a right to not do this to me. So what is claiming? It says what claiming is a kind of demand. So to claim, it's an activity. To claim is to make a demand. And he says there are two kinds of sort of activity, two kinds of activity and two kinds of we need a noun for it, claims, having a claim, performative and propositional claiming. A performative claim is making a claim to something. So only, say Jones owes Smith $50. Only Smith is in a position to make a claim to the $50 from Jones. Anybody can utter the words, Jones owes Smith $50, but it's only Smith who can make the claim to the $50 from Jones. So performative claiming is making a demand of somebody to something. Propositional claiming is a kind of utterance, is kind of speech. It is to perhaps, anyone can utter the words, the earth is flat, but to claim that the earth is flat is something else altogether. You have to belong to the Flat Earth Society or something to be able to claim that. It's to stand behind what you say. To have a claim, then, is to be in a position to do one of those two things. To make a claim to something or a claim that something is the case. Performative claiming, think of a prospector claiming the mineral rights for a piece of land. So he has to stake his claim. That involves going into the assay office with his ore sample, to stake his claim, or showing up at the lottery office with the ticket. Make your claim. So rights are valid claims. Rights, we can go back to the law, for example, of this in the civil law. To sue somebody, to bring a lawsuit, you have the plaintiff and the defendant. The plaintiff, he starts the ball wrong. The plaintiff has to do something. He has to sue. He has to bring suit against somebody. And in that case, then the defendant, ball's in his court. Now it's his obligation to respond. If he doesn't, then the case goes against him. In the criminal law, consider a criminal case where somebody's indicted for a crime. Now, what is an indictment? An indictment is not a conviction. In the criminal law, we have a grand jury, of course, where we go to the grand jury, where the district attorney goes to the grand jury to get an indictment. That is to be able to bring somebody to court. You cannot have a trial until enough evidence has been presented to get the court's attention. That's what this is. So making a claim in this case is like going up to somebody and grabbing their lapels and say, listen to me. When you have an indictment, you have been heard by the court. Now you can go to trial. Finally, we say rights are valid claims. Claims admit of degrees. They can be weaker or stronger. A right is something like a success word. There are no degrees of rights. If you have a right, you have a right, period. So if you have a right, your claim, the claim that is the core of the right, has particularly strong reasons behind it. So that's it for rights. The next topic and the final topic for moral theory for us will be on relativism.